Good morning, everybody, or rather, good afternoon. My name is Chris Justice. I'm here joining you, as I always do, an associate from Samfiru Tumarkin's Toronto offices. And like every time I come on here, I am aiming to hopefully answer as many of your questions as possible, all things employment law related. So please do, if you're watching and you have questions, get them in. And as I say, I'll go through them at some point during today's session and answer as best I can. Having said that, as I always do as well, before I get into the questions, I like to start off with 2 or 3 topics, sometimes from the news, sometimes from my own practice, my own experience. And today I want to start with one story that actually involved an Air Canada employee. This was someone who, like many of you, was laid off back when the onset of the pandemic began in 2020. And this individual, after being placed on the layoff, was not called back. And so what he did was, as many people should in those cases, he sought legal advice. And he wondered whether or not Air Canada could, in fact, place him on a layoff due to COVID for as long as it did without calling him back. And so essentially, he got some legal advice. He commenced a claim against Air Canada, an action against Air Canada, looking for his severance. This was someone who was with Air Canada for about 25 years, and they held the role of a director position, director of customer experience. And with that role came a fairly good compensation package, as well as retiree travel benefits and some other intangible elements. And so the long and short of this case is that after this individual, this director of Air Canada, commenced an action seeking his severance, he was ultimately awarded 2 years of severance by a court. And I believe the total value of the severance was in the range of $1.8 million. And part of that included one of the benefits he had, which was lifetime travel for him and his wife. And I wanted to raise this story, first of all, to give people an idea that if you are somebody who is curious to know what your severance entitlements are, whether you've been placed on a layoff without your consent or whether you've been let go from your job, 2 years gives you an idea of what the potential could be in your case. So definitely, if you're in one of those situations, whether you've been offered a severance package or not, you'll want to give us a shout. Even if you've been offered a severance package, you need to understand that whatever is being offered to you is likely going to be very, very much less than what you would actually be entitled to. And if I had to guess, this director from Air Canada was probably maybe initially offered some money at the early stages, but it's usually just not enough, and you typically have to push. And essentially that's what he did, and he was successful. So in terms of how he was actually awarded 2 years of severance, I want to quickly touch on some of the main factors that the courts look at when trying to decide how much severance, one individual or another should get. The first factor the courts will look at oftentimes is the age of the employee. So as I mentioned, this director at Air Canada, he was 52 years of age. And you'll probably notice that for a lot of people in that age bracket or higher, will typically get more severance than if, say, they were 42 or 32 years of age. So age is definitely one important factor. And the reason for that is because a lot of times if somebody loses their job and they go out and try to find another one, depending on what their age is, they may actually suffer prejudice from prospective employers, which then may end up contributing to it taking longer for that person to find work. So age is one factor. The position that you have at the time that you're let go, or in this case, at the time of the layoff, which again was done without his consent, position is another factor. So I mentioned this individual had the role of director of customer experience, and with that came a fairly decent compensation package. And so the logic behind the position being one of the factors is that there may only be so many positions like that out there that are comparable. You will probably find that if you work at an entry-level job earning minimum wage, there's going to be, at least in theory, more positions available after you were to lose your job. And so the higher the position you have, or the more rare, I guess, the position you have, generally speaking, generally it's going to take longer for you to find another job like that that's comparable. So position is another factor. The length of somebody's service is another factor. I mentioned this director at Air Canada had 25 years of service, so definitely a long-term service employee. And a lot of times people can get a month per year, or even more than a month for every year they work, depending on whether or not they find a job after they're let go, and what that sort of looks like. So definitely the fact that this guy was 52 years of age, 25 years tenure total with the company, and at a director level. All of those were the main reasons in why this person ultimately was given 24 months of severance. So there is one other factor that I haven't mentioned, and that would be whether or not you have a contract that you signed that would somehow, I guess, limit your entitlement. So a lot of times people, before they start work, they'll sign a contract, or maybe when they get promoted, they'll sign a contract. And in that contract may very well be a section that deals with what you're supposed to get in the event of a termination. And for the most part, these contracts, or these sections in these contracts, are designed to limit your entitlements in the event that you were to be terminated. So the contract is always the first spot that I look in terms of trying to figure out whether or not there's anything that exists that would restrict or limit somebody's severance entitlements. In the case of this Air Canada employee, there either was a contract without a very good termination clause in it, or there was no contract whatsoever. But definitely, again, if you're somebody who's lost their job, if you're somebody who's been laid off and it's not something you consent to, and you have no interest in going back to the company in the event of a layoff or a leave of absence, give us a call. We'll kind of take you through all these factors, and we'll give you a good idea of what your potential best case scenario is before you accept a package or sign any paper saying you'll accept some severance. Give us a call. So that's kind of the first story I wanted to mention. Now, the other thing, actually, before I get to the next topic, and this has to do with the Air Canada situation. The fact that this person essentially lost their job during the onset and in the midst of a global pandemic, that was something too that was considered, and nowadays often is considered when deciding how much severance to give somebody. There's a phrase known as the COVID bump, which essentially means that if you're somebody who's been let go during the midst of the pandemic, and you can show that your particular industry as a result of the pandemic was hit hard, then there's a chance that you might even get more severance than is normally the case. So this could apply in general if there's sort of an economic downturn or a poor economy, or more recently in the context of the COVID pandemic, which is just an extreme example of that. So that's another factor. It's not one of the main factors I discussed, but the state of the economy for sure is something to be factored in. Having said that, I wanted to move on to my next topic before I get into some of your questions. And that topic has to do with the infectious disease emergency leave. So as many of you may know, beginning all the way back in March of 2020, people, as I mentioned, have been laid off, like this director at Air Canada. And the justification for the layoff, if you ask the companies that are involved, is that they're simply placing these individuals on the infectious disease emergency leave, which was special legislation created as a result of COVID. And a lot of people, employees and employers, believe that the infectious disease emergency leave means that they're essentially allowed, or the company rather, is allowed to place them on this layoff for as long as the COVID pandemic's going on. And this has been justification and rationale given by companies going back over the last 2 years. And I and my firm in general have been trying to inform people that if you're someone who's been placed on infectious disease emergency leave, whether it's in April of 2020 or it's in April of 2022, there's a good chance that your employer does not have the inherent right to do that, despite what the legislation says. So if you're in that situation and you maybe thought at one point that they could do this, and that for that reason you've been waiting while on a layoff or on this infectious disease emergency leave for them to call you back, thinking that you weren't entitled to any severance or that you aren't entitled to any severance, I just want to make sure that everyone understands that's not necessarily the case. And so if you're somebody who's been waiting around to be called back thinking you have no other option, you definitely want to give us a call. The longer you wait, in general, when it comes to the law, the more you may be seen as having accepted what's essentially happened to you. So time is definitely of the essence. However, in the context of the infectious disease emergency leave, that actually expired as of the end of last month. So even if there was a chance that your employer could argue that they had the right to put you on an infectious disease emergency leave for the past year or two or several months, as of July 30th of last month, the infectious disease emergency leave has ended. And so companies now, going into August, are no longer able to rely on this particular piece of legislation. So if you're an employee and you were put on an infectious disease emergency leave in the past, and now we're coming into August of 2022 and nothing's changed and you continue to remain on that leave, all the more reason to give us a call. There may be some situations, some rare situations, where your employer can actually continue the leave or the layoff going into August, September, October of this year. But there's at least one less defense the company can use. That is, of course, relying on the infectious disease emergency leave. If you're somebody who's been on a leave of absence and you don't have any desire to get severance and you are waiting to be called back, I wanted also to address those people because there are certainly some individuals who do not wish to cut ties with their employer and are wondering, maybe when they can be called back. They can potentially, that is employers, as of August of this year, you can potentially still be put on a layoff of some sort for several months. So in terms of the timing, if you haven't been called back already, it's possible, not to say again that your employer has the right to do this, but it's possible for them to continue the layoff, not the infectious disease emergency leave, but just a regular layoff for a number of months further down the road. So if you're kind of wanting to know what your options are, maybe you want to go back to work and you're holding out, hoping that your company is going to call you back, or maybe you're thinking of just the various options you would have, I think it's still beneficial to give us a call. And again, at least we can give you your options or an idea, I should say, of how much longer you may have to wait to be called back. And also what happens when you are called back. Can you, for example, refuse to go back or not? Now, generally speaking, if you're on a layoff or a leave and you've consented to it and you're agreeable to it, but you're only agreeable to coming back if you can work remotely from home, because I know a lot of people have been working remotely from home, and your employer, however, is insisting that you go into the office and that they're not accepting a work from home arrangement anymore, even though that may have been the case in the past, don't assume, if you're an employee, that you have the right to tell your employer that they have to make you, or allow you, I should say, to work from home. If you're somebody who didn't work from home before the pandemic and you only started working from home after the pandemic started, you may likely not have a right to insist that that work from home arrangement stay in place. And you may actually have an obligation to go back into the workplace. And if you say no to your employer, and that the only way you're going to go back is if you can work remote, you may actually be deemed to have quit your job. So this is another situation where if you're communicating with your employer about a potential return to work, and you're thinking of telling them that you will not go back unless you can work remotely, give us a call so that we can, again, kind of take you through what your options are. There's a possibility that you could negotiate a work from home arrangement, maybe a hybrid arrangement where you work from home a little bit and don't work from home in other situations. But you definitely want to speak to a lawyer and get legal advice on how to kind of go through that process and make sure that at the end of the day, you're not saying anything that's going to hurt you or that's going to limit your options in some way or another. If your employer ultimately does not call you back and they decide to terminate you, then you're back into the situation that the director at Air Canada that I mentioned at the outset is in, and that is trying to determine what a fair and reasonable severance package is going to be in your case. Going back to those factors, your age, your length of service, your position, whether or not there's a contract in place and what it says. So you would be entitled to severance in that case. So definitely, again, all the more reason to give us a shout so we can go through that with you and figure out what the best move for you to make would be. Having said that, I do have another topic I wanted to talk about regarding pay raises. But before I get into that, I'm just going to answer some of the questions. I see some questions coming in. So thank you, as always, for everyone getting your questions in. Do get them in if you haven't gotten it in already. Send your question. But I'm going to go through and answer as many as I can right now. I've got the first question comes from Luku on YouTube, and they're asking if I request my company to I guess provide me with back pay for being on a leave of absence in 2021. Will they require that I receive no other income while I was on that leave of absence? And do they reduce the amount of back pay by the amount received from other sources? So that's a good question. I know a lot of people, as I said earlier, may have been laid off already for up to a year or two, and or placed on a leave of absence for a year or several months, whatever the case is. If you're somebody who had a job and you stopped actively working in that job, whether it's a layoff or a leave of absence, and you didn't consent to being placed on that layoff or that leave of absence, the argument would be that you were actually terminated or what's called constructively dismissed from your job the day that they stopped paying you. So if, Luco, you're in that situation and you did not consent to being placed on a leave of absence in 2021, and you've since that time not returned, you can have the opportunity to actually go back in time and look and consider the day that they placed you on that leave of absence as your termination date. Now, what that does mean, however, is that if you choose your leave of absence date as your termination date, and you do end up getting another job or earning income from other sources, then there is at least a chance that that money will have to be deducted, or there'd have to be some sort of offset. Because again, going back to constructive dismissal, that's when essentially an employer makes a change to your employment that you don't agree to. And then if that's proven that you've been constructively dismissed, you're treated in the eyes of the law as if you've been terminated. And then the same considerations go into play as though you were terminated. And one of those considerations is, have they earned money elsewhere? Have they picked up another job? When did that happen? You know, like how soon after being placed on the leave of absence did they find another job? So that would probably have to be considered in some sense or another. So Luco, if you have any further information in terms of your case, definitely give us a call, and we can kind of talk through the specifics as far as, you know, what your date of constructive dismissal would be, whether and to what extent any income earned afterwards would affect your severance entitlement, and just generally what your options are. But thank you for your question. I think it's something that applies to a lot of people. And Luco's got a follow-up question asking whether or not they can refuse to provide such info if the company requests it. And I take it by that you mean information relating to other sources of income. So it would depend on the exact source of income when you started making that money. For example, maybe you were already making that money before the leave of absence occurred, and you may not in that case necessarily be required to provide the specifics of that income, that source of income. And on the other hand, again, if you find a job after the leave of absence happened, you know, trying to make some money, given that, you know, whoever you're with is not paying you dating back to 2021, then there may be an obligation on you to disclose that information, at least at some point. You know, may not be right away. I would definitely contact a lawyer if you are being requested to provide certain details, certain information, because it may also just be your employer attempting to get as much information as possible from you, maybe not even necessarily being entitled to that information, just so that the employer itself can perhaps provide you with less in terms of an offer, in terms of compensation, or something along those lines. But thanks again for the question. I've got another question in from Georgia. Georgia is asking or saying that they only worked at a company for 4 months. They were let go and they were offered 2 weeks of severance. And Georgia's asking if she's entitled to more and if it's even worth pursuing getting more, given the fact that she was only with the company for 4 months. So it's a good question. A lot of people mistakenly believe that if you've only been at a company for a few months or a year or two, a relatively short period of time, and your employer's offered you some severance, that it's probably not worth it to pursue more severance. But that's, as I say, a mistaken belief. Georgia, depending on how old you are, what your position with the company was, what your compensation package with the company was, and of course, whether or not you have a contract and what that says, even though you've only been there for 4 months, you could get several months of severance. So 2 weeks of severance by no means should be seen as being fair and reasonable necessarily. Because as I say, frankly, you can be with a company for just a month and get a few months of severance. So I think, Georgia, it could very well be worth your time to pursue. And I would definitely recommend that you give us a call and we can set up a consultation and go from there. And this really applies to anyone who's watching who is a short-term service employee. Just don't assume that you're only owed a couple weeks or a month and that's it. There are, in fact, many cases out there of past employees who've been let go with just a few months of employment who have received 4, 5, 6, 7, 8 months of severance, believe it or not. So just something for everyone to be aware of, that there absolutely could be great potential to your particular case. But thanks for the question, Georgia. I think it's important as well for those who might have that mistaken belief. I got a question in from JC on YouTube. JC's asking, with the example that I gave earlier, how much additional severance does it add if the industry you work for has been affected? Is it a percentage or some sort of flat rate? And just to kind of catch everyone up, if you're just joining now, earlier I spoke about a case involving an Air Canada employee. And one of the reasons why the Air Canada employee I was talking about was, or ultimately did get more severance, is because they lost their job in the midst of the global pandemic. And there have been a lot of cases, or at least a few cases, that have come out where employees, because they were let go in the midst of a pandemic, and because that pandemic affected their industry, the judges ended up giving, or the judge in any given case ended up giving that person more severance. Now, JC, you're asking, is there an exact science? Is there some way to figure out how much more severance someone should get if they can show that COVID affected the industry? And just like many aspects of the law, there is no exact science. There's no bright line in terms of you get a month if this is the case, or 2 months if that is the case. I've seen, for what it's worth, JC, in my research on these cases, people get an extra 1, 2, 3 months of severance. So I guess depending on the individual, it may not relatively be a huge amount, but even still, adding upwards of a few extra months for reasons related to the quote unquote COVID bump, I think is still very much an important factor to consider. So there's no percentage or flat rate, JC. It's just something that kind of gets added into the equation, and everything gets blended together, and the judge, in theory, would sort of decide how many more months should be given. I imagine that with someone who was let go with 15 years of service, might be given a month or 2 or 3, whereas maybe someone with 5 or 6 years of service might be given just 1 more month. But don't necessarily hold me to that. It'll just kind of come down to a case-by-case basis. But thank you for your question, JC, as always. I've got some more questions in from YouTube. First with JR. JR is asking whether or not there are any good methods or processes or things to focus on after moving on from a release in terms of finding a new job. I don't know if I understand exactly what you're saying, JR. I think what you're saying is or what you're asking is sort of how do you best go about looking for new work after you've been released from one position at a company. I mean, you can definitely start with looking online, job search related websites. Typically, when someone's let go, there is an obligation on them to go out and give reasonable efforts to find a job. And usually what that means is that they go out and they try to send out job applications, because that's one of the main ways that you can prove that you're actually out there looking for work, is by showing your employer that you've sent out applications to other positions. So, you would start, I guess, with the job search related websites, Indeed, Monster, Workopolis. That would be a good starting point. I know a lot of jobs that maybe you wouldn't ordinarily take because they're located well outside your geographic region, because we now live in a more remote workplace type society. You might actually be able to take a job that's based out of Oakville, let's say, but you live in the East End, east of the GTA, because there's an ability for you to work from home. So I'd start with those job search related websites. I'd also contact Service Canada. I know, JR, you've said that you're trying to avoid unemployment. The government does also offer a job bank. So if you contact the Employment and Social Service Development Center through the government branch, Service Canada, they'll have also a job bank that you can, I think, likely access to look for work. Other areas that you could look for work, I mean, you could obviously talk to colleagues, former coworkers, maybe friends, family, find out kind of what's out there. And of course, just the classic approach or the pre-internet approach of going literally to companies and, having a resume, having a cover letter, and kind of dropping it off. I would just say that if you're somebody who's out there looking for a job because you've lost another job, just keep a record of your job search efforts. You never know when that kind of stuff may come in handy, because if you end up contacting a lawyer and having that lawyer help you get more severance, and you've done a bunch of job searching, but you actually don't have any proof or records of that could actually affect your severance entitlement. So for anyone looking for work, just keep a record, keep a tally of where you apply, what the date is, what the position is, sort of almost like an Excel spreadsheet, and whether you got any responses, any offers, that kind of stuff. But I would start there, JR, in terms of the options of looking for work. We've got another question in from Bill on YouTube. Bill's saying that he did not try to find another job after he was let go. He worked for an employer for 6.5 years. He's 65 years of age, and he's asking if he still owed severance if he in fact did not look for work. So even though I said what I just said about looking for work, what I will say that is, if you're an employee and you've lost your job and you don't have evidence that you've been looking for work, or in fact you made no efforts to look for work, that may play a role in how much severance you get. But I also don't want to say that if you haven't looked for work or you don't have evidence of looking for work, that means you have no rights. There are actually some cases out there, believe it or not, where employees or individuals went to the courts looking for severance, didn't look for work, and still got severance. Now, are they going to get as much severance? Maybe not. They might lose a month or 2 or 3, depending on their circumstances. But Bill, I think that shouldn't prevent you or dissuade you from seeking assistance if you need it. I think you should give us a call. 6.5-year employee in their mid-60s loses their job. I mean, you could technically get as much as 10 to 12 months, depending on your circumstances. So even if your entitlements are affected by virtue of you not looking for work, you still could be looking at a relatively significant package, even with that discount being applied. So yeah, definitely, whether it's you, Bill, or anyone else that's watching, if you're thinking, well, I didn't look for work, so I guess that means I'm not entitled to severance, that's just incorrect. And it's just another factor that gets considered in the equation. And these are all things that we'd be happy to talk with you about, set up a consultation and take you through everything and make sure you do ultimately get what's fair and owed. I've got another question, last question or statement from Gina Rose on Facebook, who's saying, you're lucky to get 2 weeks. I was let go while on medical leave with no severance. And I think what Gina was responding to was an earlier question from Georgia. Georgia was a 4-month employee who got 2 weeks of severance. Gina is saying you're lucky to get 2 weeks because I got nothing and I was let go on a medical leave. Well, Gina, I'm glad you've raised that. If you're an employee who was let go while you're on a medical leave of absence, or you could be on a maternity leave, you could be on any sort of leave, maybe a childcare leave, and you've been let go, you've been released from your position, there may very well be a very good chance that you're actually not only just owed severance, but also owed human rights damages. The argument would be, had it not been for the fact that you were on medical leave, you may not have lost your job. And so anytime employers let people go while they're on a medical leave, or upon returning from a medical leave or maternity leave, or any of these leaves that are protected, there's a big issue as far as that's concerned with the human rights people. So the employer may be in a lot of hot water. And Gina, if you were let go while on a medical leave and you got zero severance, I highly suggest you give us a call, and we'll be happy to talk you through it. Because, as I say, not only could you be looking at severance, potentially significant severance, but also extra compensation for that violation of human rights. But having said that, that is my time for the day. We are doing these things all the time, these live Q&A sessions. We've got Darren Saul tomorrow, as you see noted down below there, 1 p.m. Eastern, 4 p.m. Pacific, and he'll be happy to answer as many questions as possible. So if you didn't get your question in today, definitely join in and watch Darren. And I'm sure he'll be happy to answer any questions. But having said that, as always, I thank you very much for your time. I hope everyone has a great rest of their day, and definitely do take care. All the best. Bye for now.